Yeah, fine. So, good afternoon, all. Today, I'm presenting about SEBI regulations towards warrant pricing. We are discussing this regulation through 5 case studies about the scams that have done by multiple companies. So, we are discussing about 5 companies. So, first we'll discuss about what is warrant pricing and what is equity shares. So, first of all, we are dividing this entire presentation into 2 sets. First, we'll discuss about warrant pricing case studies. Then we'll discuss about equity shares case studies. So, first of all, what is equity shares? Equity shares is a direct ownership, like buying house at an outright. So here the mechanism was investors pays the full price upfront. That means the investor will pay the amount fully at the initial stage. But in warrants, warrant is a right, but it is not an obligation. So here the warrants are a right to buy shares later at a fixed price at a future date. So here the analogy was paying a deposit to lock in the house price for later. Here the mechanism was investor pays a fractional deposit upfront. If the stock price rises, they pay the balance and convert it to shares. If the rate was fall, they walk away and forfeit the deposit. So this is the how we are differentiate about warrants and equity shares. So here is the a blueprint of how the scams are happening. So the first step of the scam was like cheap allotment. In this is the first step, like as an entry step. If the insiders acquire massive equity at a price far below the market value, like in via warrants, fake loans, or extreme discounts, then the next step is like the price will be inflated. Here, the insiders use mandatory lock-in periods to pump up the stock using fake news, fabricated orders, or withheld penalties. The next step, like the third step, is the insider exit. Once the lock-in expires or the lock period is expired, insiders dump their inflated shares onto retail investors at the absolute peak. So this is the step how these companies were got scammed. So we are moving to the case studies. First, we are discussing about warrant price or preferential allotment via warrant price case studies we are discussing. So first company is Apexion Global. It's the timing scheme. So basically what happened in this case was promoters expanded share capital around 1550x by issuing warrant to themselves only, and during the artificially suppressed stock prices. After pumping the stock into 60x, they dump shares on a retail investors while hiding a 480 crores GST penalty to delay the panic. So here, how they violated the law was like warrants were used to lock in cheap conversion prices by gaming the relevant date. Equity shares were then dumped on a public immediately after lock-in expiry. Here, the law they have violated were LODR regulation 30 and the ICDR regulation 164. We look into these 2 laws. So, LODR regulation 30 were discussing about the disclosure of events or information. Here, every listed entity shall make disclosure of any information or information which in the opinion of the board of directors of the listed company. They want to make the full disclosure if anything happen into the company, if they have any debts or if they have anything, they want to disclose all their informations. That these kind of things were disclosed in regulation 30. So in regulation 164, ICDR regulation 164, it is showing that if the equity share of the issuer have been listed on a recognized stock exchange for a period of 90 trading days or 90 trading days or more as on the relevant date, the price of the equity share to be allotted pursuant to the preferential issue shall be not less than higher of the following, or 10 trading days. They want to take the amount as a 90 trading days or 10 weeks average amount. 10 trading days. So we are moving into next company. Here the Omnicord company. Here the promoters issued equity warrant exclusively to themselves across multiple listed companies. Here the promoters issued, like multiple companies issued their like warrants to multiple promoters at a percentage of 10%. Before the SEBI converted into 25%, first the percentage was 10%. So here, because only a 10% deposit was required, they treated it as a risk-free bet. Here the promoter treated this warrant as a risk-free bet. If the stock rose, they exercised for massive gains. If it fell, they walked away. 1,515 crore was forfeited across 8 large firms. Here, first they issued the 10%, they acquired the 10%, then if the company, if the price was inflated, then they will occur the issue. If it is go down, if the price is, suppose if the price is 100, if the lock-in price was 100, if it is goes by 120, they will acquire this. If it is go down like 80 or 70, they will forfeit this and walk away. So here it is this is actually happened here. If the stock rose, they exercised for massive gains. If it fell, they walked away. So here 1,515 crore was forfeited across 8 large firms. So here they violated like warrants. Here warrants were structurally abused as free call options rather than genuine capital raising instruments. So here they violated ICDR regulation 169. So this is the ICDR 169. Here it is mentioned that if in the case of warrants, after this massive abuse, the SEBI in 2019, the SEBI changed the 10% upfront amount into 25% after this case. In this case of warrants, an amount equivalent to at least 25% of the consideration determined in terms of regulation 164 shall be paid against each warrant on the date of allotment of warrants, and the balance 75%. So here we want to first pay the 25%. After the if we are like after the expiry date, we want to pay the balance 75% of amount. 2009. 2009. These are not original companies data. These are for like study purpose. We have generated these names. So next we are moving into preferential allotment via equity. Here direct exploitation through extreme discounts and fabricated capital. So here we are in this case we are discussing about here in this company, they have revenue about 0. The company allotted 51.51 crore shares to 6 connected entities, claiming was converting 1,000 crore loan into equity. First of all, they have zero revenue, so they have converted the 1,000 crore loan into equity shares. But the thing is that through the SEBI investigation, it is come into light that the loan entirely fabricated. The loan was entirely fabricated. There is nothing loan like that. So this loan is also fabricated. So here they violated like equity shares. No, here there is no warrant were used. This is only based on equity share scam. The fraud was executed via a fake debt instrument, granting insiders 99.28 control for effectively zero real cost. So here they violated ICDR 164 and the 2024 independent violation rule. First, then they converted this debt like 1,000 rupees crore loan into equity. Then they give that shares into shareholders. So actually, they have like near zero revenue. So they fabricated the loan amount and they converted that amount into equity shares. Involving undeferred creditors. Because they want to they want to be in the stock market and they want to grow. There is no money company. So there is no company. So they are like fabricated. They are using into share market. These loans were converting into share market. So here they violated ICDR 164. Pricing of frequently traded shares. Here also they are violating the 164 that I have already mentioned. Like 90, they will take the price as average of 90 trading days or 10 average of 10 trading days or 90 trading days. Here this company also violating this ICDR 164. Pricing of frequently traded shares. Yes. Like this is a SEBI formula they have implemented. So if you are fixing a price, you want to take the average price of 90 trading days or 10 days. 10 days. Yes. Recent prices. So next is here the company executed 6 rounds of preferential equity allotment to raise funds instead of using the capital. Here the company issued the capital legally, but after that the using of the capital for the stated business purpose, directors secretly loaned the money out to undisclosed third parties. They have raised or issued the price in a legal form, but if the amount they have collected, they used into a third party. They use secretly loan. They use this money to directors secretly loan the money out to disclose third parties. They have given to the this amount to third parties. Here, which are not disclosed. Which are not disclosed. They didn't. They stated like for some purposes in the this amount were this amount was stated for some business purposes, but they have allocated this money for other purpose which are not stated in the document. So here The initial issuance was legitimate, but the equity raises were weaponized as a repeated extraction mechanism. The fraud occurred entirely post allotment. After the allotment, they changed this money to other purpose. They given this as a loan to third parties. Here they have violated LODR regulation 32. That the LODR regulation 32 have mentioned here, the list entity shall submit to the stock exchange the following statement in respect to utilization of funds. Category wise amount of money is raised, category wise amount of money is utilized, balance amount remain utilized. So this is the LODR regulation 32. The listed entity shall submit to the stock exchange the following statement like the use of proceeds from the object stated in the offer document or explanatory statement to the notice for the general meeting, or they want to submit what purpose they want to do through this money. They want to they want to disclose all the things, and then where an entity has raised funds through preferential allotment or qualified institution placement, the listed entity shall disclose every year. They want to disclose every year the utilization of such funds during that year in an annual report. They want to disclose these all things into their annual reports also. So this is the last case. So here the company allowed shares to 41 insiders at 10 rupees when the market price was 120. They have they have allotted shares to the insiders just for 10 rupees, but the market price was 120 during that time. One day before the lock-in period expired, they created six fake subsidiaries and announced fabricated corporate orders to pump up the stock for their exit. So here they have just allotted the promoters for just 10 rupees, but the market price was 120 during that time. So here direct equity was allotted at a 91% discount to market value. The mandatory lock-in period was mathematically weaponized to the time the exit. Here they weaponized the lock-in period as their weapon. So here the law they have violated were ICDR 164 and LODR 30. So awarding, bagging or receiving amendment or termination of awarded or bagged orders or contracts not in the normal course of business. These were the law they have violated here. So here also they have violated the average pricing formula and also the disclosure of events or information. Every listed entity shall make disclosure of any events or events information which in the opinion of the board of directors of the listed company is material. Like they want to disclose all their information into their reports, documents, everything. They want to disclose all of their performance and like if they are moving in a downfall, or if they have any debts or kind of things, they want to disclose everything. So here they won't disclose anything. So they have violated LODR 30 and ICDR 164. Fake, fake announce. They created fake announcement. Yeah. Huh. Fabricated stock into their exit. They pumped the price by creating fake announcement, fabricated corporate orders, fake subsidies. Yes. Nine, average price. It's the last line. So here we have discussed about the preferential allotment via warrant and equity shares, the scams that they have done through warrants and equity shares. Now I'm calling Taruni to take the class forward.
So, good afternoon all. So, I'll be walking you through OFS promoter holdings and selling restrictions. So, this will be mainly on how much a promoter can hold and what are the restrictions on him selling the shares. Okay. So, first, let us understand why there is a lock-in period. So, when a company promoter issues IPOs, if a promoter sells their shares immediately, then it will lead to public holding all of the companies. So SEBI doesn't want that. That is why it got in regulations to control minimum amount of holding for companies, for promoters in a company. So we can see here promoter lock-in after fresh issue of shares. So when a company issues fresh capital, SEBI mandates promoters cannot sell their shares immediately. These lock-in rules protect retail investors from promoters cashing out their listing. So there are a few things you have to understand here. So minimum promoters contribution is around 20% of post-issued capital. So the lock-in period for this is 18 months from the allotment date, and this is for the standard one. And if they're using this money from the proceeds for the capital expenditure, then the lock-in period is for 3 months from 3 years from the allotment date. Second is excess promoter holdings. That is, if a promoter holds above 20% in the whole company, then he has to hold it for 6 months from the allotment date. And if he's using those proceeds for capex, then he has to hold it for 1 year from the allotment date. And the third one is free issue shares, but these are for non-promoters. So they have to hold, in both the cases, they will have to hold it for 6 months from the allotment date. And coming to venture capital firms, alternative investment funds, and foreign venture capital holdings, so they will be having the same as non-promoters, around 6 months in both the cases. So capex IPO is basically when the proceeds are used for the company's maintaining of physical assets or acquisition of any other company. So here, yeah. And you can send. Yeah, I'll talk about it in the next coming slides. And yes. Yeah, it's for 3. Yes. So if it is above 20%, then they would have to hold for 6 months and 1 year for capex. Yes, and anything above is hold for 6 months. Yes, depending on the way they are using the money. If it's for capex, then it is for 1. And then for free shares, you are non-promoters to hold for 6. Yeah, 6 months. Non-promoters. Yes. Here it can also be a group of promoters, sir. They can collectively hold up to 20%. I'll talk about in the coming slide. So this is a screenshot directly from the SEBI's report. Just check the highlighted points here. Promoter group or other than promoter group referred to the provisions to sub-regulation 1 of the regulation 14 shall be logged in for a period of 18 months from the date of allotment, and provided that in case that majority of issue proceeds excluding the portion of the offer from the sale is proposed to be utilized for capital expenditure, then it is to be logged in for 3 years from the date of allotment. And promoter holdings in excess of minimum promoter's contribution shall be logged in for a period of 6 months. And provided that in the case of majority of issue proceeds excluding the portion of offer for sale is proposed to be utilized for capital expenditure, then the shares shall be locked for 1 year from the date of allotment. Over here also you can see that locked in specified for specified securities other than promoters. So in that case, they will be holding locked in for 6 months. So now we'll talk about the minimum contributions or minimum holdings that a promoter should have in a company. So SEBI mandates a minimum level of promoter skin in the game to ensure accountability and long-term commitment towards the company post-listing. So this is the 20% rule under SEBI's ICDR regulation 18. So it says that minimum a promoter must hold at least 20% after the shares are being sold. So it must be fully paid up equity shares, and they should not include warrants or any kind of convertibles. So these shares must not be pledged. Pledged is basically when you loan your securities, you get loan based on your securities. You loan them to the bank as collateral, and then you get money to use it for your business or for capex. And then calculation is based on post-issue capital as at face value and not the actual IPO price in the market. So now let us see what if a promoter holds less than 20%. So you see all of these in growing companies like startups, right? So what's regulation SEBI has for them? So the original rule is before there was only promoters. So promoters can only contribute towards issuing of the capital to get it to 20%. But this was pre 2024. So now SEBI has relaxed these rules. So now alternative investment funds, foreign venture capital funds, and scheduled banks, insurance companies, all of these can contribute a maximum of 10% of the post-issue capital. And in phase 2, you can see that promoter group entities have come into pictures. These are nothing but a group of people coming together. That they are called promoter group entities, and any non-individual public shareholder holding more than or equal to 5% of the post-issue capital can also contribute maximum of 10% of the post-issue capital. Okay. So this is again a screenshot from SEBI's report. As you can see, the promoters of the issuer shall hold at least 20% of post-issue capital, provided that in case of post-issue shareholding of a promoter is less than 20%, alternative investment funds and foreign venture capital funds, investors or commercial banks or public financial institutions, insurance companies, they have who are holding at least 5% of post-issue capital can contribute a maximum of 10% of post-issue capital.
case it falls to less than 10-20%, then these companies are the foreign
Yeah.
BCI banks, have to hold maximum.
Yeah, they can contribute maximum of 10% to the company.
In that case, there is a relaxation.
Yes, sir. That was, and then there is a second phase of the relaxation where they allowed promoter group entities and non-individual public shareholders who have at least 5%. They also can contribute a maximum of 10%.
About this, promoter group entities maximum 10%. Say promoters holding is standard 15%. That is available if you have all these under the phase 1.
Yeah.
Holding maximum 10%, or you have phase 2 relaxation. So anyone who's a promoter or any non-individual public shareholder holds greater than 5% less than 10%. That is.
Yes.
How low can
I should look on. I will. Yeah. Yeah, I will come back with that question, how low a promoter can go with their share. So now let us see what are the OFS limits, how much a promoter can actually sell. So an offer for sale allows existing shareholders, including promoters, to sell their shares at the time of IPO or as a listed company. This is called the OFS mechanism. So SEBI limits how much shares can be sold or cashed out. So there are caps for this. So first, this is the minimum as we have seen. So if a promoter holds more than 20%, then he can sell up to 50% of their IPO shareholdings. But if they hold less than 20%, then they can only sell like 10% of their shareholdings. So over here, promoters as a group, they have a combined cap of they must retain at least 20% of the post-issue capital after OFS sales. So let us look at an example now. So a promoter holds 40%. So this is more than 20%, right? So over here, a promoter can sell 50% of his shares, which is 20%. He will sell and 20% remains with himself. Now, next, VC holds 15% of pre-IPO shares. Now, as the rule says over here, they can only sell 10%, maximum of 10% of the shares they have. So that will have, they can sell 1.5%, which is 10% or 15% in OFS. So next we'll see the minimum. There is a rule that SEBI says that before a company is listed, the promoters have to hold the securities for at least 1 year to be eligible for OFS. So before a promoter can offer shares in the OFS as a part of IPO, those specific shares must be held for at least 1 year before the DHRP. DHRP is nothing but draft red herring prospectus that a company must file with the regulatory authority. So before that, the company must, the promoters of the company must hold their shares for at least 1 year. So SEBI proposed clarifying whether this applies to shares received via conversion or fully paid up compulsory converted basis. So these shares must be fully paid up and they can't be in form of warrants or convertibles. And shares bought or allotted in the past 12 months before the DRPH at the price, DRHP, DRHP filling at the price below IPO are ineligible for OFS. Next, we'll talk about post-listing selling. So after the locking expires, there are a few compliance and obligations that they have to follow. Let's look at it. So SEBI insider trading regulations. So a trader cannot trade during trading windows if they possess any kind of insider information that is unknown to the public. and the second one is the LODR regulation. So they must disclose to the stock exchanges any sale of 1% or more of the total sales. So even if they are selling even 1% of the sales, they have their shares, they have to tell the regulatory authorities. Next is pledge disclosures. Any pledge or revocation of pledge, promoter shares must disclose within 7 working days of this event happening. You can, yes.
Correct.
Yes, sir. Okay. So these are the screenshots again from SEBI. So this talks about the threshold accordingly in regulation 6 of 2 IPOs shareholders with over 20% of shareholdings cannot offer more than 50% for sales, and shareholders with less than 20% cannot offer more than 10% for OFS. And over here we can see it has been clarified that the price per share is determining the eligibility of securities acquiring in the last 1 year of filing the DRHP for minimum promoters contribution under regulation 15 of the SEBI ICDR regulation. So they have to hold the shares for at least 1 year before this DRHP is been filed. Okay. So we've come to the almost the end of the presentation. So now let's see what happens when a company is restructuring or being merged with any other, or there are any other not so common in, situations that happen in a company. So let's see what are the regulations in those cases. So first is merger and amalgamation approved by NCTL. NCTL is the National Company Law Tribunal. So in case of merger or amalgamation, lock-in transfers to the resultant company and they are not released. So the minimum holdings is transferred to the other company shares, but they are not being sold off to the public. Second is demerger and spin-off. So the lock-in continues on new company shares received in exchange. So the next is transmission by death or succession. If any promoter dies or there is a succession happening, so the lock-in transfer is to their nominee or their legal heir. And then next one is inter-transfer with promoter group. So here the lock-in continues. So these are not released, but just simply transferring within different groups. So they are again not sold off to the public, but within the group they have been transferred. And coming to pledge and pledge invocation and lender enforcements. So locked-in shares cannot be transferred even on pledge invocation. So if a company is pledging the shares to the bank and getting some money in return, these type of shares cannot be transferable to any other person. Next is the insolvency resolution plan. So this is by Indian Bankruptcy Code. So restructuring under IBC approved by NCTL may create alternative treatment. So these are exempt from SEBI scheme approvals in certain cases. And the last one, ESOPs or SARs. So these are exempt. So SARs are nothing but so these are basically when these are bonus amount given to the employees when there is a rise in the price of the stocks. So they can the difference is given to the companies as bonus, employees of the companies as bonus. So these are also exempt for 6 months non-promoter pre-IPO locked in as per amendment 2025 of ICDR.
They can sell.
What's the?
They can sell. What does that mean? What is the meaning?
So they are exempt. That means that they can sell, sir. It's not that they have to have the shares logged with the company.
That's a recent.
Yes, recent one.
Went from the 6 months non-company. So they can, employees can sell.
Yes, sir.
Is there any regulation that the ESOP should have been allocated money?
No, there is no such. I'll come back with it, but as far as I've gone through the document, there is no such regulation. Yes, I will. Sure. So this is again a screenshot from SEBI's document. So, subject to provisions of Securities and Exchange Board of India, substantial acquisition of shares and takeovers regulations. So this specifies that uh, promoters and locked in shares as per regulator 16 may be transferred to another promoter or any other person in the promoter group or a new promoter, and the specified securities held by person other than the promoter and the logged in as per the regulation 17 of ICDR may be transferred to any other person holding specified securities which are logged in along with the securities proposed to transfer, provided that the logged ins on such specified securities shall continue for the remaining period the transferee, and such transferee shall not be eligible till the lock-in period. So as since these cases that we have seen, they are exempt from the actual lock-in that SEBI says. They have their own conditions. So not in all cases that you have to have the securities locked in for 6 months or 1 year or 3 years. So it depends on the kind of situation that happens.
Last paragraph says that transfer to another person so they can transfer, and the locking will also get transferred, provided that the locking of such specified securities said with the transfer of such transferring shall not be able to transfer to them with the locking period stipulated in
सर ये जैसे कि मर्जर्स हो रहे हैं ना, तो उनके केसेस में the lock-in is transferred, but they cannot actually go sell out the shares, right? So they have to, in those situations, they have to abide by the lock-in rules. But in other cases, that is expense. हाँ, हाँ. Okay. So the key takeaways from this presentation are: first, are locked-ins. So the key takeaways are: first, are logged in. So minimum promoter contribution shall be 20%, and which are logged in for 18 months in standard cases, and in case of IPOs, it is logged in for a period of 3 months. Sorry, 3 years. So next is minimum contribution. A promoter must hold at least 20% or above 20% of post-issue capital. Shortfall up to 10% can be filled by AIF, banks, and other insurance companies that we have looked in the previous slides. And the next is OFS limits. So if a promoter holds more than 20% of shares, they can sell 50% of their stake. And if they hold less than 20%, then they have a max cap of 10% to sell their stake. And these, provided that these are held for 1 year before DRHP filing. And the last one is: in case of any restructuring or mergers, demergers, succession, or any intertransfer, these are, remember that these shares are not released. That is, these are not sold, but they are transferred to the new holder. Thank you. I
box before two. So effectively means that you cannot go for 10%. Say shortfall of the 10% can be filled by AIs. That means the promoter can go 10%. But what
I will.
Yes.
I'll come back with that.
Just take note of
Yes, I will. So I would invite Naveen to continue the presentation.
Yeah, good afternoon, everybody. Before going to the topic, thank you. Not, okay. Uh, Sorry for the glitch. Good afternoon, everybody. Before going to the topic, today we went through OFS and warrant pricing. Thank you for that, my team. Now, before going to this topic, let's build a small story around it. Like, there is a company named ABC. So this company, they have issued shares before. Now, what happened? They wanna build a factory of 100 crores. So because of this reason, they wanna issue some shares. They went through debentures, everything. Now they need an additional capital of 100 crores. Because of this, they wanted to issue some shares to the existing shareholders. So let's go one by one. What are the SEBI norms and regulations that will protect the investors, and what are the norms that ABC should follow before issuing shares? So there are some simple norms as per the report of regulation 2018 of SEBI under ICDR. So these reports will tell us about what are the regulations that we have to follow and what are the regulations that will protect the existing investors and the new investors. Let's go one by one. So these are today's topic: the eligibility requirements, convertible instruments, record date and leading managers, disclosures and filing, fast track, post issue, issue procedure, pricing. The name looks little strange and some difficulties, but the meaning is very easy. So let's go through it one by one. So eligibility criteria. What are the eligibility that a company should have before they are issuing rights issue of shares? The major thing is that it should be more than 50 crores. The amount that they are raising, it should be above 50 crores. Otherwise, it will be difficult to issue a rights issue for the existing shareholders. This is the major thing. And according to the report, it's here mentioned over here. Another thing is that SEBI will go through some documents, and those documents are listed out twice before it's listed. Like before it is drafted, and second is when it is finally issued. So we can see why it is done. Why they have to check it twice? We may think it is a waste of time or something. But if ABC company, it's legal now. Before drafting, it's legal. But after drafting, they may see that it's free. Now it's free. Now they are not scrutinized. So during final issue, they may create something which is against the norms. So to avoid these confusions and to protect the interest of the investors, these things are taken care so that they will be checking twice in a year so that the draft and the final issue matches with each other. So that's the thing which is an appreciable from SEBI regulations. That's the one of the filing draft of letter and the filing final letter. This statement talks about these things. Then the second thing is entity is not eligible. Like we can see some of the promoters, some of the companies or some of the investors who are banned from SEBIs because of their past experience or past activities. So these people are completely restricted or banned from issuing new issue of shares or from getting rights issues. So this is like general conditions for rights issue. So what are the general conditions that we have to take care? So here we can come across three different percentage. One is 75, one is 75, one is 25%, another is 35. So here what happened was 25% and 35% are interlinked with each other. So let's go with this first. So whenever a company, our ABC company, let's say they are issuing a share of 100 crores. So they have to make sure that they have at least they can use only 25 crores after collecting this from rights issue. That is the statement. Like amount earmarked for general corporate purpose in the offer document shall not exceed 25 crores of the amount raised. Let's see, they have raised 100 crores for the factory. That is their general purpose. So when amount is raised, they have raised around 100 crores. They can't use all of them. They can use only 25 crores. That is the 25% of the amount they have raised. So this is for the single motor. Let's say they have raised this amount for two different reasons. One is for the factory installment and another is for the salary they have to pay, some other things. So in this situation, we have to go through this percentage. When we have combined cap, then then the exceeding amount can't cross 35%. In our case, it is 35 crores. Like we have raised 100 crores, that 100 we can't use, ABC company can't use more than 35 crores in a combined cap for two different purposes. So now let's see what is 75% then. 75% is whenever a ABC company, whenever a company is raising rights issue, they should make sure that they have raised 75% of the capital that they are going to raise. Let's say they want 100 crores. So they should have 75 crores with them prior raising this issue. So they should arrange for 75 crores before they are raising for 100 crores of rights issue. This is the simple thing. Why this is done? So SEBI look into that, like these companies are not going into any bankruptcy or they are not issuing shares simply for without any reason. They should make sure that we have particular reason and that amount is used specifically for that reason. So these things are kept in mind. So because of these things, we can safeguard investors and promoters. So in 2018, SEBI had made so much norms to safeguard the interest of promoters and investors. Because of this, India was profitable and we can see less scams in these situations thanks to SEBI. So we have come across some general conditions and general norms. Now let us see what are the convertible debts and warrants. Warrants, my friend has explained you regarding warrant and warrant pricing. So we will go through what is convertible debts. Let's say we need 100 crores of funds. So what we will do, we will take a loan, we will take a debt of 100 crores for 3 years. We will take it for 3 years. And after 3 years, instead of repaying the money, we will give them ordinary shares. In simple term, we can say equity share. We will issue them equal amount of equity shares that worth rupees 100 crores so that debt could be converted, that could be recovered. Like instead of paying them cash or any monetary terms, we are giving them equity. So this is a debt instrument. The instrument that is used to convert this is called as debt instrument. So we have certain norms how we can do this. There's all instruments can be converted into debt or there are certain norms. Let's go through it one by one. So obtains credit rating from less than 1. So SEBI registered CRA. These are the norms of 2018. So now they have come across some amendments, and we can see we have used Companies Act 2013. So this helps us to make sure that the uh, debenture trustees are maintained. So debenture trustees are those parties who will make sure that the person who is issuing the loan gets the money safe and sound, that there is no bankruptcy or there is no issue that he faces any problem in getting back the money back. So there is the major thing, debenture trustees are kept in point. So another thing is, so asset securing CDI must cover principal or at all time, be free from encumbrance, have lender consent for pari passu charges. Like these are like when if we fail to pay them the money that we are recovered, we have to pay them penalty. This is a simple term. So here it's given in a complex thing, but it's in a simple term that we have to pay them penalties. But that instrument is not related to rights issue of share. It was a small topic, that's why it was covered in my slide. So now now let us look into what actual topic is. This is very important for rights issue. So record date and lead managers. Lead managers play very vital role in rights issue. Let's know why and how. Record date. The issuer must announce a record date to determine shareholders' eligibility to apply for specific securities in rights issue. Like they should mention the record date in this, like on July 1st or July 5th, I'll be issuing a rights issue. We should record that so that issuer and the shareholder gets a specific amount of time to arrange for certain capital. Like it's not rated for 100 or 20 rupees. It's in crores together. So nobody has so much amount to be accumulated in single time. So we will be giving them specific amount of time so that we get accurate amount of capital that we require. So record date is very much important. No withdrawal. Once the record date is announced, the issuer cannot withdraw the issue date. Let's say I am an issuer and I will tell them that my company will be issuing a rights issue on 5th of July. So all investors, they will be ready with the money. But later what happens? Prior investing and prior the record date, I will tell that no, I will be issuing on July 10th or July 15th. Because of this, what happened? Indirectly, it will hamper the trust of the investors and the promoters. So next time when I am issuing the rights issue, then I will be not getting that confidence from the promoters. So these things should be avoided before we are issuing a rights issue. Penalty for withdrawal. If withdrawal after the record date, the issuer cannot apply for listing for any specific securities on any exchange for 12 months from the record date. Like this is the penalty that has been implied on me. Like if ABC company sets a date and it fails to issue on that particular date, so for 12 months it cannot issue another rights issue. So that's the penalty that SEBI imposes on certain companies, so that we should be very clear and peculiar with when we are recording the issue date. So disclosure and filing of letter of offer. So letter of offer, we can see there are two letters of offer. One is the draft and another is the final record. So as I discussed earlier, draft and final record should match with each other. We can't show our financial statements as 100 crores in draft and 200 crores in final letter. So that will not make a balance, and it doesn't have a complete disclosure. It may hamper our confidence as well. So disclosure in draft of letter. All material disclosed must be true and adequate to enable informed investor decision. This is according to Schedule 6. So lead managers shall exercise due diligence and verify veracity of all disclosures. Like lead managers are very important. The role of lead manager is he should make sure that what all documents we are issuing, are they correct. He will verify that, and he will make sure that lead manager is very important till we are issuing the rights issue to the investors. So he plays a vital role in any rights issue of any company. So financial information must not be more than 6 months old from the issue opening date. This is very important. The third point is very important, because let's say ABC company files its financial statement that its net value is around 100 crores, and they say that we need to raise a capital for around 20 crores, sorry, 200 crores. For 200 crores. So what happens, they should make sure that this valuation that they have calculated should be correct, and we are not changing this for less than 6 months, because SEBI and other regulators, they will be verifying this. If we are changing the financial statements for more than 6 months, then it will be very difficult for us to track the financial records. So because of this reason, we should be very clear about our valuation and the amount that we are raising. So this is the financial statement, like more than 6 months we can't change them before issue of rights issue. So if issuer or any promoter or director is a willful defaulter or a fraudulent borrower, must be disclosed in DLOF, or here we have to disclose regarding who is the issuer, who is the promoter, and is there any fraudulent activity that happened in past. All these things should be disclosed in our letter of offer. So my dear friends, this is the very important thing. For rights issue of share, pricing is very much important. So we can't price it according to our needs. We have to look into certain criteria before pricing our rights issue. So issue price decides in consultation with lead manager before the record date. As I told you earlier, this person, lead manager, he is very important for issue of share. That person decides what amount should be raised, what are the documents should be pledged, and what are the documents that he has to verify. So unless and until he gives a green signal, no company can issue its rights issue. So he is a very important person until and unless we close the rights issue. So issue price shall not be less than the face value of the specified security. It cannot be less than face value. Like our face value is 10 rupee. Our face value is 10 rupee, and we can't issue it less than our face value. Then it doesn't make any sense. The record date is determined in consultation with the designated stock exchange. Like we have to take a approval with BSE or NSE. This is the stock exchange, the designated stock exchange. In a sense, before giving a rights issue, we have to make sure that we are taking a permission and approval from them, and with their green signal we can give a rights issue. So issue price must be disclosed in the letter of offer filed with SEBI and stock exchanges. We have to make sure that issue price is disclosed in DLOP and with the letter that we have given to our NSE or BSE. And these should be approved by both SEBI and the respected stock exchanges that we are approving. So both approvals are very important before we are issuing. So because this is a matter of price, and investors are giving their hard-earned money for our company's rights issue, though that's a very important thing. So reservations like compulsory convertible debts and employee reservations. Like rights issue of equity shares can proceed only if the reservations of equity share is made for holders of compulsory convertible debt instrument in proportion to the convertible part. This is about the convertibles, like debt instrument that we talk about, that we just discussed. So this is a compulsory thing. Like for every shareholder, rights issue of equity shares can proceed only if reservation of equity shares is made for the holders of the compulsory convertible debt. Like it is a compulsory thing, it's not an optionable thing for them. For every person who is a shareholder, it is compulsory for them to be converted into rights issue. Another thing is, for the people who have worked for us, we need to take care of them as well. So SEBI makes sure that employees are also getting some benefits of rights issue. So they say that reservation for employees may be made along with the rights issue. Allotment to any employee max 2 lakhs. In case of under subscription, max 5 lakhs per employee. Like if an employee is also trying for rights issue, then he should given a he should be given a special preference. So this is regarding the SEBI's norm, so that employee also gets a rights issue and a share in a company. This is a very important thing. ASBA is very important because of this we can protect the interest of the promoters. Let's say a promoter pays money from his bank account and he doesn't get a share back, or it is blocked due to some reason. So in this case, if money is not received back, then his money will be refunded back to his account, or some certain extended days will be taken from the company so that shares can be allotted to him. If that doesn't happen, it should take place. A share should be issued within 4 days of ASBA. If this doesn't happen, then 15% of interest should be paid by the company to the respected issuer or respected shareholder. If let's say he has issued for, we need to pay him around 50,000 rupees. So with 50,000, we need to pay a 15% additional interest. This is the penalty for breaching of the contract, or we can say for not issuing share on time. So here we can see the materials, ASBA and key timelines. Like availability of LOF and materials. LMs are the lead managers, must ensure LOF and application forms are available at stock exchanges, registrars, DPs, brokers, underwriters, bankers and SCSBs before opening. Like before we are opening, before the opening day of the issue, LM should make sure that all these people have availability of application that are issued for, what amount of price, what are the shares that we are going for, how much it is listed for. All this information should be disclosed with these people. Then we can say credit of right entitlement. Right entitlement is, let's say we have a ratio of 1:4 for rights issue. So for every 4 shares, he will be getting 1 rights issue. So he will be getting around 25 shares. If he has 100 shares, he will be getting around 25 shares. So this 25 shares are called as RE. That's the rights issue that he will be getting. That's his rights for the existing share that he has. So we should make sure that in the opening date we are mentioning the ratio, and we will make sure that the share that he should get, it's his right, and we need to allocate it on time. Plain paper application, like shareholders without application form may apply in writing on plain paper with required money. Like such application cannot renew their rights. Like what happened was, applications are not given. So sometimes what happened, application may not be given or some issue might happen. So because of this, shareholders should not lose their interest. So to protect them, we are renouncing their rights. So we will be giving them, if applications are not made on application form and plain paper, both are liable to be rejected. Let's say here what happens, without application form, we can also give we can also apply for shares like on spot, or we can give them a proper definition why it is not happening, and if it is properly defined, then they may get an rights issue. This is about prohibition of incentives. Like we can't tell anybody that if you get a share, we'll give you extra cash or we'll give some incentives. Like wrong promises should not be done. Then security deposit, like this is very important thing. Before opening subscription, the issuer must deposit with the designated stock exchange 1% of the issue size. Let's say ABC is issuing 100 crores. So 1 crore rupees, 1 CR should be kept as a security deposit with BSC or NSE. Let's say if ABC is getting approval from NSE, so they have to keep 1 crore with NSE as security deposit. That's the promise that I am making. Like, I will be issuing the current amount of shares on right time. There's a small question that what about this 1 crore? Will the company get it back? Yes, of course they'll be getting it amount back, because once the closing date is done, then NSE or BSE, the respected stock exchanges, they will refund the money back to the company once all the procedures are done according to norms and regulations. So this is the security deposit that they will be facing. Another thing is underwriters. Underwriters are very important, because we are dealing with lot of big huge amount. So we can't say that 90 we have a norm that 90% of shares should be subscribed, otherwise we can't issue rights issue. So because of this, what happened, we will be having some underwriters. We'll ask them to purchase the leftover shares. Like, say only 80% were subscribed, 10% are still lagging. So these underwriters will buy those shares for us, and later it will be sold out in the market. So this is about the underwriters who play a very important role. So this is about monetary agency, advertising and issue opening. So this is also one of the important thing. Like, monetary agency are done so that they could monitor what all things are happening, all the documents are correct or not, all prices are been fixed properly or not. All these things are monitored. So when a company issues more than 100 crores, so for those companies, monetary agencies are mandatory, and they will go for monetary agencies. So advertisements and issue opening. So here we can say a monetary agency must be appointed if the issue size exceeds 100 crores. Exception banks, public financial institutions and all. Who monitors? The monitoring agency must be a SEBI registered credit rating agency. Since amended 2022, it was amended in 2022, and we can't say anybody to monitor it. It should be SEBI registered. So here also we are protecting it. It's one of the best thing that SEBI is doing for us. So reporting frequency. The monitoring agency submits quarterly reports, schedule 11 format, to the issuer until 100% of issue proceeds are utilized. So quarterly they will be monitoring it, so that there is no chance of making any fraudulent activities by the company. Broad comments. The board of directors and management must provide their comments on the monitoring agency filing. So board of directors also have some freedom. They can give a comment regarding how it is monitored, are they satisfied or not. All these things can be done. Public disclosure. Within 45 days from the end of each quarter, the issuer must appoint the monitoring agency report on its website and submit to the listing stock exchanges. So this should be done so that no fraudulent activities can be entertained. Here we can talk about ads and issue opening. My dear friends, tell me one thing, how we will get to know regarding a particular company is issuing so much shares? Only because of ads. From newspapers, from their official websites, from mails, from these things we can easily get to know that some ABC company is going to issue certain amount of shares. So ads play a very important role in rights issue. Publicity complaints, like all public communications, publicity materials, advertisements and research reports must comply with schedule 9. So these are like all these advertisements, all these things should be classified, and it should be according to schedule 9. So issue related advertisement, like digital language newspaper. So here it says that these advertisements are published in English newspapers, then Hindi national newspapers, so that it could be easily approached to public. Public should know whether this company is issuing rights issue or at what price and in what time. So this is the main motto of this. So closure announcement. Closure announcement can only be made after LMs certify that less than 90% of the offer has been subscribed certified by the registrar. Like, we can close the advertisement only when LM, very important person, he will say us that yes, we have reached our 90% of our subscribes have been subscribed, so now we can close the advertisement. Till then we can't close, and the deadline will be minimum 7 to maximum 30 days. So when once we are issuing it, we should make sure that we meet this deadline. So issue opening deadline, the rights issue may be opened within 12 months from the date of SEBI's observation. For fast track issues within 12 months from the record date. Let's say we will ask approval from SEBI, and SEBI will tell us that yeah, you can issue it on July 1st. So we have to make sure that we are issuing it from July 1st 2026 to July 1st of 2027. Before 12 months we have to issue our rights, and we have to make sure that we are meeting this deadline. Otherwise, after 30 days, if our promoters and investors, 75% of promoters and investors agree that we can exceed our time, only then we can exceed, otherwise we can't. So that's also one of the major norms that SEBI has come across with. So this is about subscription allotment and refund. Minimum subscription, at least 90% of the offer through the offer document. Like this is like who can how many subscriptions we should have, that I spoke earlier. So period of payment, like as I told you, minimum 7 days and maximum 30 days we should make sure that rights issue are done in these things. Payment options, issuer shall offer shareholders one of the part payment on application. Like as I told you, this is a huge amount, so everybody can't pay in one shot, so they will pay in part by part. Like if I want 1 CR of rights issue, I will say them that give me an installment on half yearly basis or quarterly basis, so that I could meet my requirements. So this is a good option that companies and SEBI is providing to the investors. Then manner of calls, outstanding subscription money must be called within 12 months of allotment. Like outstanding, we can't say that who all will apply for those many amount of shares will be subscribed. It could be sometimes overstated, sometimes it could be understated. So it depends upon the situation and the company's norms and brand value. So we have to make sure that we are satisfying each and everybody. Let's say there is a equal amount, like we have asked for 100 CR and we got 100 CR of money raised, so there is no problem in that. If we asked for 100 CR and we are getting a raise of 125 CR, so the 25 excess amount are overstated. So we should make sure that everybody get at least amount of shares before we are giving preference to the new shareholders. So allotment procedures, priority order, full allotment to eligible shareholders who applied for rights entitlement, full or part are re-announces. Like here the thing what I told you, this is explained here. Like if it is oversubscribed or undersubscribed, or sometimes what happens, the rights issue will be sold out, they will be selling this to another shareholder. So these things they will be entertaining at the last. They will see that the person who has major shares or who has listed for minimum amount of share will be getting the minimum shares that he has allotted for. Later the exceeding shares will be taken into priority. Allotment, refund and interest. Allotment or refund must be completed in SEBI specified period. All allotment and refund must be done electronically. If not completed in time, the issuer shall pay interest of 15 per annum to shareholder. As I discussed this point, if we fail to pay them on time, so we should pay them with 15% interest per annum to the shareholder. So these things were discussed earlier. Post issue responsibility and release of funds. Like now issues are done, everything is done, so we will see what are the post responsibilities that a company has. Like post issue advertisements are LM must publish an advertisement within 10 days of completion of issue activity, disclosing subscription details, basis of allotment, number, value, percentage of all ASM BA applications, successful allotments, all these things, so that we will get a clarity regarding how many shares were sold, on what date it was sold, how many shareholders we got, how many rights issued were completed, it was overstated or understated. All these informations will be there so that we could match with our expectation and actual reality. So this is one of the major thing. So lead manager post issue duties, like these are his duties regarding continue until application receive credit to their demat account of refund. We can't say that his responsibility is till you receive the share. Let's say a existing shareholder got a share, he has allotted, he has asked for a share and he is not at all allotted till now. So LM's responsibility is that each and every shareholder gets his allotted shares. So until then his responsibility will be pending. Release of subscription money. LMs must confirm to bankers that all formalities are complete before releasing process to the issuer. If listing or trading permission is refunded, entire subscription money must be refunded within 4 days of rejection immediate. This point was disclosed before, like we have been given 4 days of time after the maturity period, like the date will be 1st of July for allotment, and if we fail to do that we will be getting an extension till 4 days. After that, even if we fail, then we have to pay them penalty for 15% of interest per annum. So promoter transparency report, like all security transactions by promoters and promoter group between date of filing and date of closure. So this should match. What are on the date of filing and date of closure, we will make sure that how many shares were allotted, all information will be disclosed in this paragraph. So post issue reports, like lead manager must submit initial post issue report, then within 3 working days of closure, then final post. Here we will get an actual clarity about what was our plan and did we get or not. Like our example was ABC company wanted 100 crores of share. They issued 100 crores. So this was the initial post issue. He will make sure that initially this is our plan. So at the end, he will make sure that really did we achieve this or not? How did we achieve that? How many shareholders we got? How many existing shareholders bought it? For what ratio, what price? Everything will be disclosed in this para, including refunds. Miscellaneous provisions, like restrictions on further capital issue. An issue shall not make any further issue of specified securities by and more public rights, preferentials, QIPs, bonus, etc. Exceed further. Fast track issue, other issue. So these are like, so here we can see restrictions on further capital issues, like what are some of the restrictions that we may face, like from date of filing LOP with stock exchanges until listing of refund or monitors, like other issues like from date of filing DLOF with SEBI until listing or refund of monitors. Exceptions. A further issue is permitted if full disclosure. A further issue is permitted if full disclosures regarding the total number divided by amount of further issue are made in DLOF or LOF. Like this says that the further issue is permitted if full disclosures regarding the total number is divided by or further issue are made in DLOF. Like it should be mentioned here. There's a simple thing that we should be mentioning here, how many shares we should issue. That's the main thing, disclosure. So general rule, altering of rights. General rule, the issuer shall not alter the terms, including terms of issue of specified securities in a manner that adversely affected the interest of holders. Like we can't change the rules. What we will be telling in initial days and initial term, that should be followed till the closure. This is the general rule that we should follow. Exception for this is alteration is permitted only with written consent of holders at least 3/4. This I have mentioned this, that any specific changes can be made when 75% or 3/4 of our existing shareholders give approval for that. let's say we made a norm that we will be giving you dividend of 10 rupees per share, but later we will see that the company may not make such profits, so we will reduce it to 8 rupees. So if 75% or it's in fraction 3 4 both are same, so if 75% of our shareholders agree to that, yes, we are we are okay with 8 rupees of dividend, then this can be approved and this will be followed. If they reject this, then it can never be followed. We have to go with the earlier norms that we have promised them.
Dividend is not the right example here. Dividend is not fixed.
Fixed.
So just say that if there is anything alteration in the terms of the secretary, supermajority
We have to 3%. So
just say that it's complete.
it's like on the specific securities, if anything, if we have promised and it's not met, then we have to take a in terms. Okay. If any term changes, then we have to take a super majority and we have to go with it. Promise. This is the last thing, like how we can fast track everything. So here we can say that at the last thing is the 99th regulation. Here we can see till 60 to 98, it is for the it talks about the interest of the promoters. Here we can see that LM should make sure that company doesn't make a fraud, all gets their allotment, everything. So shareholders. So here what happened was, we will be a small freedom will be given to the companies as well under this. Like if that company, they will NSE or BSE will make sure that they will see that whether this company is listed in our stock exchange for 3 years, how are their behavior, compliances, are there any complaints raised on them, are they paying tax regularly, all these things are verified. And if everything is verified and they will be given a green tick, then they will be given a exception not to give a DLOF. Like this takes lots of time, so this time period can be reduced. So for those companies who are very well versed with their practices, if they are following their norms properly and all, so this regulation 99 will give them a time period, so they could reduce the time and they could issue shares prior to that in a short span of time.
Those conditions are just read out one by one. There's 3 years.
Yes, sir. Listing history of here. Equity shares listed on any stock exchanges for at least 3 years, immediately preceding. Yeah, demat holding has to be there. Then they should have average market capital of public sharing at least 250 crores. So that's the one thing. So then annualized trading turnover of equity share during 6 calendar months preceding the preference month, at least 2% of the weighted average list equity shares. So issuer with less than 15% of public sharing, 2% of free float. Like here it tells us that trading turnover, how the trading turnover should be there, like intraday turnover.
2% of the
Equity
share of the market. So if it is less than 15%, then 2%.
2% of the free float
should be traded
daily.
That's it.
Yeah, that's the term.
Delivery is in your demat account. Should be traded security.
Oh.
Should not be dead security.
Second.
So 2% should be traded on a daily basis in the 6 calendar month preceding the
Difference.
So it should be traded.
It should be traded for
and 2% of the market cap should be traded on the daily
2% of the market cap should be traded on the daily basis. That's the
period of 6
period of 6 months. That's the one of the norm. Then delivery based turnover, like annualized delivery based trading turnover is at least 10% of the annualized trading turnover during the preceding 6 months. So here it should be at least 10 months,
delivery based transaction
10%
of
of the free flow. Here it should be 2% for daily basis. Here it should be 10% for annual basis.
for delivery.
For delivery
For
basis.
delivery trades can be analyzed.
Okay.
And for trading can be
Monthly basis.
in the last 6 months here
Annual. This should be 10%.
10% of the total free float people should have taken home in the demand.
Home the demand.
Just
Yes, yes. So listing complaints, complaints with the listing agreement like SEBI LODR, as we spoke about this, regulations 2015 for at least 3 years, non-compliance with board composition that has since been rectified with adequate LOF disclosure is deemed compliant. Monetary files by stock exchanges alone do not disqualify. Like there should be no much complaints with them. There should be no complaints raised regarding these
there
companies.
should be compliant. And some monetary fine has been
Imposed,
then it does not
qualify,
disqualify.
disqualify. Yes.
For 3 years they should be listed.
3 years they should be listed.
3
Yeah.
years of
Listing companies. So this is grievance redressal. At least 95% of the investor complaints received till the end of the quarter immediately preceding the preference month must have been distressed. Like at least 95% of the investors complaints must be resolved. So if 100 like 95%, they are giving so much priority to their complaints and grievances. So this is the major thing. So no pending SCN by SEBI. No show cause notices excluding penalty proceedings issued by SEBI pending against the issuer, its promoters or whole time directors as on the reference date. No notice issued on them. SEBI. So SEBI shouldn't have any notice period on them, like they should not notice them. There's the major thing. So here we can see that if a company goes through all these things, then they'll be given a special preference not to file DLOF, which could reduce the time span for rights issue of shares. So this is the summary regarding what all we discussed today. These are the major points. Like fast track, this is the important thing. Because this is only one point where we think about the companies. From 60 to 98, it is all about the promoters, investors. Investors.
99
The promoter, the investors. Yes.
50 crore trigger,
Key threshold 50 crore trigger, 90% minimum subscription, 7 to 30 days window, 15. This is like who can issue shares, like rights issue. The amount should be more than 50, equal to or more than 50 crores. That is the minimum criteria. Then how many should be subscribed? Minimum 90% should be subscribed. So for how many day window they'll be getting? For 7 to 30 days. So if they fail to do that, they should pay an interest of 15% per annum.
they don't refund the money.
Then they have to refund. So this is about promoters. This one. All amendments up to 2022 are incorporated. Thank you. Yes. Thank you. Thank you. Thank you. Thank you.